Our legal system is actually incredibly proficient at seeing physical violence. Think about it. A robbery, an assault, a bombing, these are loud, visible wounds that trigger immediate legal responses. We know exactly what to do when blood is spilled or glass is broken. But what happens when a life is destroyed quietly, like without a single physical shot ever being fired? Welcome to today's Explainer, where we're going to dive into a really stark, honestly terrifying contrast. A legal system that completely excels at policing violence, but is completely blind to the quiet, bureaucratic destruction of a human life.
We are dealing with a profound contrast here. On one hand, we have visible victims, those harmed by war, crime, and physical violence. We have a robust, highly developed moral and legal vocabulary to describe their suffering and help them seek justice. But on the flip side, we have this chilling absence of language. We're talking about the invisible victims of the peaceful state. These are everyday people whose lives are systematically ruined by administrative power, entirely under the radar.
Let's start by looking at Section 1, the visible victim.
Now, our international and domestic laws perfectly recognize physical harms. If your body is injured, criminal law steps in. If your property or money is stolen, we've got private law and restitution. If your home is destroyed in a conflict, humanitarian law is there. But there's a quote that captures our topic perfectly. War is terrible because violence breaks through the legal order, but peacetime administrative destruction is disturbing in a different way because it may occur inside the legal order. That is the terrifying reality we're exploring today. The very state machinery designed to protect us can actually inflict profound damage from within its own legal procedures, record-keeping, and silences.
Which brings us to Section 2, the invisible casualty.
What we are seeing today is a totally new type of casualty produced by the state's own protective architecture. Legal scholar Janina White has been doing some incredible work mapping out this administrative harm, and she exposes how our current public law simply lacks the tools to recognize these hidden injuries. The harm to the citizen is 100% real, but the legal language required to actually fight it, it's just missing.
White actually defines this completely new category as the victim of peace. This is an individual whose life is functionally and severely damaged in a cumulative, institutional way. So there is no single dramatic legal wound, like a bomb dropping or a bank being robbed. Instead, they face opaque decision-making, unverified security proxies, and just a massive wall of institutional indifference that slowly suffocates their professional and personal life.
So, how does this actually happen? Let's get into Section 3, Weapons of the Peaceful State.
How exactly does a peaceful bureaucracy inflict life-altering harm without firing a single shot? Well, mundane administrative tools become literal weapons. We are talking about unseen internal notes, silent database flags, informal risk labels, and institutional silence. There's also this thing called procedural displacement, which is basically where an institution routes your complaint into the completely wrong channel purely so it can be rejected on a technicality later. These tools distort a person's life, creating exclusion and suspicion without a single shred of verified evidence ever being presented to the victim.
All these administrative weapons create what is known as the administrative shadow, essentially an Alsatia of executive action. Historically, Alsatia was a lawless sanctuary in London. In modern terms, it's a lawless region inside the state where executive power is effective enough to completely ruin your life, but insufficiently formal to be legally reviewed by a judge. The victim is governed by these devastating consequences, but they're denied the procedural status to actually challenge them.
Moving on to Section 4, Effect without a decision.
Institutions use this Kafkaesque legal loophole to deny accountability. They generate a massive real-world effect without ever making a formal decision. Let's walk through a real-world scenario. Step 1. The state applies a hidden risk flag to a citizen's profile based on, say, an unverified rumor. Step 2. The citizen is suddenly denied access to their workplace or maybe escalated to the police. Step 3. When that citizen demands a fair hearing in court, the state's lawyers claim, hey, no formal decision was ever made. It was just an internal note. Operationally, the individual is treated as a severe security risk, but procedurally, they are dismissed as a non-person when they ask for fairness.
Fighting this isolating, overwhelming labyrinth of the modern administrative state forces the victim to become their own investigator, archivist, and lawyer. It's a full-time job. Responsibility is fragmented across a dozen different departments, and that missing official who actually wrote the damaging note, they're never found. The burden of visibility falls entirely on the person who has already been crushed by the system.
If we ground this issue in legal precedent, we can look at the Anufrageva case principle, beautifully summarized by Lord Steyn, who said, "Surprise is the enemy of justice." The argument here is simple but absolutely profound. A hidden administrative act cannot lawfully bind a person who is procedurally ambushed. If you're given no notice, no reasons, and zero chance to challenge an internal measure, well, the rule of law has entirely failed you.
Let's look at the human cost in Section 5, the stain of suspicion.
The damage inflicted on the victim of peace isn't just legal or financial. It carries a devastating social and psychological toll that outlasts any court case. This stain of suspicion relies on one incredibly dangerous assumption held by society. Public authorities do not act for no reason. Because of this baked-in belief, the mere presence of a state security label instantly damages a person's social reality. Friends, employers, and colleagues naturally just assume the institution must have had a good reason to flag you, even if that flag is entirely baseless. The label does the reputational work long before it is ever tested.
In this battle, there is a severe, almost laughable structural asymmetry. On one side, the institution controls the record, the language, the timing of disclosure, and the official posture. On the other side, the individual controls almost nothing except her own persistence. She has to reconstruct events from fragments while managing fear, exhaustion, and intense reputational anxiety. And bearing this psychological burden isn't just a side effect, it's actually a core part of the administrative injury itself.
So, what do we do about this? Let's jump into Section 6, a challenge to public law. How do we actually fix this hidden crisis of administrative impunity? Well, White asserts 3 vital changes for public law. First up, legal standing must follow operational effect, meaning if the state restricts you in the real world, you should have the standing to sue, regardless of your formal status. Second, claimant-specific effects must automatically trigger the right to reasons and review, even if the state brushes it off as an internal note. Third, remedies absolutely must include social repair and recognition. A quiet payout just isn't enough. Apologies and public record corrections are vital to clear that stain of suspicion we just talked about.
If we don't fix this, we remain trapped in what's called the taxpayer paradox. This highlights a massive democratic failure, where public money is actually used twice. First, to fund the institution's unaccountable, harmful behavior, and then again to fund its wildly expensive legal defense and any eventual compensation. It completely insulates the officials from ever feeling the cost of their mistakes or actually learning from them.
Finally, we absolutely have to look at the future, which means talking about artificial intelligence. White presents a really crucial vision for AI here. If it's used as an administrative weapon, AI will simply automate these opaque classifications and multiply hidden suspicion against citizens. But if used as a diagnostic tool, AI can be a real game changer. It can map how harm travels through the bureaucracy, tracing institutional failure, and identifying exactly where human accountability went missing. It shouldn't replace judges, right? It should supervise the state machine.
Today, we've seen how internal notes, hidden flags, risk labels, institutional silence, and denied accountability can quietly, systematically destroy a human life. Which brings us to our final, provocative thought for you to consider. Can public law recognize the casualties of its own peaceful machinery?